are watching my estate planning, probate, and elder law video blogs. And these are short blogs that I discuss some topics relating to those subjects on very briefly and hopefully in language you can understand to sort of educate everybody on those issues. This month I'm starting out, I've done this for about 2 years, and I'm circling around to some basic information, and I'm talking a little bit about wills. The question I'm going to ask today is, what happens when I die if I have a will? It's a big question, but you may want to know the answer, because a lot of people go ahead and get wills at their local stationery store, on LegalZoom, or other places, and may not know what happens when the will is actually activated. So what does happen? Well, if you have a will and you have assets that value over $150,000, then your estate is going to go through a court process called probate. And whoever you've named in your will as your executor will be the responsible party for bringing those actions in court. They most typically will need to hire an attorney, and that attorney gets paid according to state law, depending on the value of your assets, how much your house is worth, how much your bank accounts are worth, how much your savings are worth. And that value is calculated on the gross value. So if your house is worth $500,000 and you owe $300,000, the fees will be computed on that $500,000 figure. So your estate will go through probate. It could take 3 months, or excuse me, a minimum of 4 months. Typically it takes about a year. If you're married and you and your wife have, or you and your husband have wills that mirror each other, so if she dies, the husband gets it. If the husband dies, the wife gets the assets. And then all your assets will pass to your husband or wife. And your husband or wife can probably change the will, their own will, if they choose to after your death, and potentially change the distribution of assets after your husband or wife dies, which is probably okay in a family that's not blended, that in a long-term marriage with children, you know, the likelihood of the surviving parent to change their will is small. But more and more today we have blended families where there's stepchildren, and so that is a bit of a pitfall. And if you both have wills that quote-unquote mirror, look at each other and give it to each other after one spouse dies, there's a potential that the deceased spouse's children in a blended family situation lose out on their inheritance. So those are some things that happen if you have a will and you pass away. What happens to your things? Again, it's a court process called probate, and a transfer to a spouse of your assets. And if you have no spouse, it'll be a transfer to your children through that court process.